Hello, everyone, and welcome to this talk titled A Practical Intro to Data Science and the Law. So it's a different perspective to a point in relation to data protection and data use. We're welcoming a 15-minute lightning talk with Sheridans. Stefano Debolini will be presenting the talk. He's a partner at Sheridans, combines a background in computer science and over a decade in law to advise tech companies, brands, and investors on AI, IP, blockchain, and data privacy. He manages software projects, delivers AI services, and navigates regulatory challenges. Stefano also writes on IP and cybersecurity, lectures, mentors startups, and advises various industries on the legal implications of data use. Can we please welcome him? Thank you.
Thanks very much. Sorry, I've come down with a bit of a cold today, so if I'm a bit scratchy, I apologize. I've got some slides. Before I get into those, I thought this morning that it might be worth, can I have a look at how does the law arise in practice for something very basic? So I thought, okay, let's say you've got my profile here on our website. I wrote a bit of code to, let's say that's in your history, wrote a bit of code that gets your last visited web page, pops it through the OpenAI API, gives you a summary, and spits out Stefano Debolini is a partner at Sheridans, specializing in IP, digital media technology, background in computer science, blah, 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 blah. Now, just that very simple step actually engages the GDPR, the Data Protection Act, involves contracts, data processing agreements, and the privacy and electronic communications regulations. So there's, even for something relatively innocuous, it turns out that the law can play quite an important part. So I'm going to look at some of those issues and what they are, how you deal with them, why we care about them today. I work at a firm called Sheridans. We've got offices in Soho and Berlin. I'm a partner in our data and technology team, so focus quite a lot on B2B, SaaS, that kind of thing, and data protection, but the firm itself is full service. So I'm going to give a bit of a whistle-stop tour of a range of different areas of the law that are relevant to, hopefully, some of you in this room, what the law is, why it matters, and some of the practical steps that we might need to think about when building platforms and systems using data science. I'll probably rush through it relatively quickly. It's going to be a quick talk because I'm probably the most boring person you'll hear from today. There's a lot more exciting stuff going on. So I won't go into things in too much detail, but if there's time for questions at the end, then please feel free to raise them or just come and grab me afterwards. You might be familiar with some of the areas that I talk about. If anyone thinks that I need to speed up or you want to jump in and ask for a bit more detail, feel free to. So the first thing I'm going to talk about is intellectual property. Intellectual property rights, there are a range of them. I've listed the headlines here on this slide. Copyright is the IP right that protects the software you write. You write a piece of software, you own copyright in that software. Or more commonly, your employer will own rights in that software. That gives you or your employer or the owner the exclusive right to reproduce, to copy that software, and to do various other things with it. Designs, these come in multiple flavors. There are registered designs, unregistered designs. They protect things like the aesthetics of a product, the configuration of a product. Similarly to copyright, you can own design rights once you come up with a novel, original design. Some designs are registrable, which can give you a longer term of protection and wider rights. And they could be useful, for example, in some cases, to protect things like a UI, as well as physical products. Patents protect innovations, ideas. So while copyright stops someone taking a copy of your code, patents potentially can provide a more powerful right so that if someone implements your idea without actually copying your code, you may still have a claim against them. Traditionally, it's quite tricky to get patents for software, but that doesn't mean they're necessarily out of reach. Trademarks protect branding, so your name, your logo for your business or your products, and similarly to other IP rights, give you an exclusive right to use your brand in a particular category of goods or services. So something that's a bit interesting about trademarks is that you register them for the specific goods or services that you're using your brand for. This is why, for example, Polo, you get Polo suites, Polo t-shirts, Polo cars, and different businesses can own the same name for different sectors, effectively. Databases are protected as well by an independent right in the UK and the EU, and similarly to the other rights we're talking about, they give you exclusive rights to exploit the investment that you've made in collating and pulling together a database. Confidential information I mentioned here, it's not typically thought of as an IP right, really, but it's often bundled in with it. Effectively, if you have confidential information and you communicate it under circumstances that mean that everyone knows it's confidential, you may have a way of protecting it if someone leaks your confidential information later on. You may have a contractual right if you sign an NDA, that kind of thing. And a lot of this stuff is relevant to training data, so training data obviously not an IP right, but one of the questions that one of the issues that comes up when I'm working with clients is, oh, we found this online, it's public, so it's public domain. Clearly, we can use this to train our models or deliver our services. There's a very important difference between public and public domain. One does not mean the other. There are some quite interesting cases going through the courts at the moment you might be familiar with. Grab me if you want to chat about them a bit later on. But just because something is public doesn't mean you're free to use it. You may well need a license to use training data to train a model. There are some narrow exceptions, but I just wanted to flag that. So that's a quick whistle-stop tour of IP. Now, in the same way as people often ask, right, I found this data online, does that mean it's public domain, I can use it? I often also get confronted with a question along the lines of, well, we found this personal data online, does that mean we can use it? So personal data, the processing of it, is governed by the GDPR. I'm sure you've all heard of it. You may be familiar with it. One point I wanted to flag here is that the concept of personal data is much wider than people often expect. So you don't need to have someone's name or address. You don't need to be able to, you don't actually really need to know who someone is for the data to be personal data. You could have, for example, an identifier, a user 123. Their favorite film is anything with Ben Affleck in. And even if you don't know who that user is, that does not mean that the record you're holding isn't personal data. If it could allow you to single someone out, for example, if someone returned to your website or platform and they had that user ID, then data that looks non-personal may well be personal data. So what personal data are you responsible for? There are concepts in data protection law of, yeah.
So like the IP address is personal data then? Based on the example you just gave.
It could be, yes. So let's say, for example, say you've got NAT translation, then probably not. If you've got a lot of people sharing an IP address, it won't be, but it certainly could be. Yeah. Does that answer your question?
Yeah, I mean,
So regulators have issued guidance suggesting that, yeah, it may well be under certain circumstances, but obviously, everyone in my office is sharing 1 or 2 IP addresses. That's not going to be personal data about us. But a cookie, for example.
from home.
Yeah, from home, it could be, yeah. Yeah, absolutely could be. So in data protection law, you have concepts of controllers and processors. The controller is the person who decides the means and the purpose for using personal data, the how and the why. Why are we getting this data? What are we going to do with it? And it's the controller that ends up having most of the responsibilities under the GDPR, some of the more important ones. And 2 of the important responsibilities I'm going to flag here are transparency and lawful basis. So what we're getting at is, if you're a controller of personal data, you need to let people know what data you're using, why, who you are, how you're sharing it, how long you're holding on to it, that kind of thing. And that can be quite tricky sometimes, particularly if you're sourcing data from someone else in an indirect fashion. That can be quite difficult. Then secondly, a lawful basis. This is the legal justification you need to process someone's personal data. So if you're doing anything with personal data, you have to pick one of these, and there's an exhaustive list. The ones that are most relevant, I suspect, to the people in this room are legitimate interest, consent, contract, legal obligation. So consent, quite self-explanatory. If I consent to you using my personal data for something that you say you want to use it for, then that gives you a legal justification. Consent can be tricky sometimes, partly because you may not have a direct relationship with the individual, but also partly because anyone who gives consent is free to withdraw it at any time. So if you collect someone's data based on their consent, start doing something with it, and then they withdraw their consent, you may have to unpick what you've been doing. So that makes consent quite difficult, particularly in the context of the kind of things I imagine a lot of us here deal with day to day. Contract, if you've got a contract with someone that requires you to handle personal data, you might need someone's bank account to pay them, then that gives you a legal justification. You might have a legal obligation to collect someone's personal data and do something with it. Again, that justifies it. Legitimate interest is an interesting, quite complicated concept, but the idea is if you are doing something with someone's personal data and you or anyone else has a legitimate interest in that processing, then that can provide a justification as long as you can demonstrate that what you're doing doesn't have a prejudicial impact on the people concerned. So, for example, you may well have a legitimate interest in building a cool model that achieves an objective, or improving your products and services, or marketing. And as long as the way you do that can be shown not to unreasonably or excessively impact the rights or the freedoms or otherwise detrimentally affect individuals, that can give you a right to use personal data without getting consent, that kind of thing. Coming back to the question I spoke about with copyright, what if it's public? You can't just find a data set online, do whatever you like with it. You still need to jump through all of these hoops. I'll just go through this quite quickly. So I spoke about controllers. Processors are the other role that are quite important. If you use someone to, these are your service providers, your suppliers. So if you use someone to host data for you, if someone's providing an API, or Pinecone, storing the stuff that you're using for some sort of RAG application, there are certain obligations on you as a controller, including you need to have a contract with them in place that regulates their use of personal data. So that contract will say, for example, you can only use personal data on my instructions for these purposes, you've got to keep it secure, and so on and so forth. So that's controllers and processors. There are a whole host of other obligations under the GDPR involving restrictions on how you transfer personal data internationally, keeping records, putting in place data protection and other policies. If you're using data for high-risk purposes, or if you're using a lot of data, or you're doing something quite innovative with it, you may be required to carry out what's known as a data protection impact assessment, or certain other assessments. And this is just look at the risks posed by what you're doing, find out how risky they are, find out how you can fix that risk, and justify how you're going to go about that without effectively potentially harming people. You might also have to register with data protection authorities, that kind of thing. So I've got a couple of other just final bits and pieces to talk about on data here. Enforcement, why do we care about this? First of all, we want to do the right thing. Our customers want to know that we're doing the right thing. Also, the fines are potentially significant. If you get things wrong, it can be a fraction of your global annual turnover. It could be up to tens of millions in fines. Obviously, that doesn't happen very often, but this regulation does have teeth. I wanted to touch on anonymization. This is one area where I find a lot of businesses working with data struggle, because anonymization legally is much harder than you expect. It's not a case of simply chopping the names off a database or removing the email addresses. If you have records that could indirectly identify someone, combined with other information you get your hands on, then the data you're holding won't be anonymous. It will be personal data, even if it's pseudonymous, which means that you still have to comply with all of these rules. So I just wanted to flag that. It's quite a tricky topic, that, but let me know if you want to talk about it and get nerdy about differential privacy, that kind of thing. Automated decisions, this is a hot topic. If you've got a system that makes an automated decision about someone that could have legal or similarly significant effects on an individual, then they have a right not to be subject to those decisions. It's not an entirely clear area of law at the moment, but some examples of where this might kick in are things like credit scores. You know, if you've got a platform that uses technology to make an assessment about someone and that is then used in a way that affects them, their right to not be subject to these decisions may be relevant. Breaches, I flagged this because if you have a personal data breach, which could be a leak because of a security incident, but could actually be much wider than that. If you're subject to a security breach and no data is actually leaked or accessed by anybody else, but they theoretically could have had access to it, that will amount to a personal data breach under the GDPR. And it means that you've got 72 hours to figure out what's the risk. Do we need to tell anyone? You might need to notify the authorities. You might need to tell individuals. So just wanted to flag that. So in the UK, we don't have specific AI regulation. In the EU, we do. I'm sure you've all heard of the EU AI Act, if you're here. It's not all in force immediately. These obligations come into play over the next 18 months or so. But in brief, there are certain AI systems which are unacceptable. So things like social scoring, using AI to exploit people's vulnerabilities, minority reports, so that I'm talking about using someone's behavior to predict whether or not they're going to commit future crime. There are also categories of higher risk systems which are regulated. So this is stuff like using AI to monitor how well your employees are performing, tracking people's behavior, location, and health using AI. These higher risk systems will need risk management processes in place. You may need to provide information to the authorities to explain how they work. You might need some human oversight, and there are a range of other obligations as well. General purpose AI, so this is AI that's got myriad applications. One of the key kind of concerning for some people in industry obligations here is that you'll need to provide a summary of how training data has been collected and used to train the model. And you'll need to have processes in place to help comply with the copyright issues I spoke about earlier. You may also need to tell people that are using your platform or system or the model what are the limitations on it, what are its capabilities. So it's going to be interesting to see how that pans out. We're looking at, yes?
Stefan, I'm just curious what your view is from a UK perspective.
I just wondered what your view is from a UK perspective. I don't want to draw you into anything sort of political because we've got a new government, but it seems to me that this sort of follows GDPR in the sense that the EU AI Act came out, it has come out, GDPR came out, it was a European regulation, and the UK, I would suggest, has a more onerous approach. So, be interested in your thoughts.
Yeah, it's an interesting one. So there was a consultation. The government came out with a white paper. They said, we don't think we need AI-specific regulation. We think that a patchwork of the regulation that we've got, so plugging together things I've been talking about, IP, product safety, data protection, and coordinating regulators will be enough. Since the change in government, I think that's still the status quo, although the new government has suggested that they're looking at potentially targeted regulation to govern more powerful AI. I'm not sure what that means necessarily, although I'll get to that in a second. So we may see some more targeted regulation, but for the moment, I think in the UK, it's going to be a case of regulators working together and if there are gaps identified, figuring out how to deal with that. But I'm inclined to agree, personally, with their approach. I don't think we need new sweeping AI regulation I think that the Information Commissioner's Office, the Competition and Markets Authority, I think regulators are increasingly equipped to help manage these risks for us. But happy to talk about that after. On the subject of powerful AI, so under the EU AI Act, this, I think, refers to effectively any models that involve more than 10 to the 26 flops of compute to train them. And there's an assumption that they pose a systemic risk. You may or may not agree with that. And what this means is that there'll be an expectation for adversarial testing of these systems, red team this stuff and see how dangerous really is it, and incident monitoring and reporting. So that's some of the headlines of the EU AI Act. As with the GDPR, why are we worried about this? We want to do the right thing. There's going to be consistent market practice emerging, and the fines could be huge. So that's the EU AI Act. I've got a slide here on contracts, cookies, and consumers, but actually I'm not sure that this is necessarily, I'm conscious of time. I don't know whether, maybe I'll stop here, and if anyone's got any questions or anything in particular they want to chat about, and if not, I can chat about this stuff.
Sorry, my name is Majid, and it's a very rookie question, actually. If I want to start in law here regarding data, where to start from?
Interesting. So in terms of what subjects to study, what stage, do you mind me asking what stage you're at?
I'm a senior data analyst in TCS,
Okay.
But I was always fascinated about tech laws. In India, it's not very mature at the moment, and I feel like we have to be very more educated in that.
Yeah.
So where to start from there? I mean,
so I've always found, both just from working with clients and from recruitment and building our own team, that a good tech lawyer can't just be a good commercial lawyer, can't just be a data protection lawyer, can't just be an IP lawyer. You have to have all three. And I'd say that getting ahead of the game when it comes to regulation is probably your best bet. So because ultimately you will deal with commercial law principles. If you can get a grasp of the GDPR and how regulation works, and which will obviously help you with things like the EU AI Act, then that'll put you in a great position to build on that and get into tech law. And industry experience is often overlooked, but really valuable.
Thank you so much.
So, currently we seem to be having an AI revolution, data revolution, and of course, in previous, times, the UK and other societies have had all kinds of revolutions: industrial revolution, internet, mobile, and of course, even aerospace and laws have kind of, gone up and evolved, as those things have come out. Now, now compared to how the law has evolved for previous things, such as, for example, the Industrial Revolution, the rise of factories and all that, do you see the law evolving in a different way here, similar way, somewhere in between? How do you see that happening compared to previous revolutions?
Interesting. I think somewhere in between, but so to add some flavor to that, there is industry-specific regulation for example, financial services, for medical devices. The FCA is already issuing guidance about how you can use AI with retail customers and how you need to manage those risks. The MHRA is probably going to end up reclassifying medical devices that use AI into higher risk categories. So I think that it will be, I suppose I don't know whether I'm getting at evolution or revolution, but certainly it feels evolutionary to me. And I think you can do that without a sweeping sort of EU AI Act, although I'm not saying that's a bad approach. That's particular to a certain set of circumstances. But I think we will see industry and vertical specific regulation expanding to encompass AI. Does that make sense?
Yes, it does make sense. Thank you.
Initially, you mentioned that databases were protected, copyrighted. But, for example, LLMs or other products are developed by some computation project using data, is that naturally protected? Is that a database?
An LLM.
Or, or other systems? Because I have an investment in time and to generate the artifact. Is that automatically like a database?
So, yeah, that's an interesting and difficult question. We don't know legally the answer to that yet. I think I'd probably be able to formulate arguments in both directions. On the one hand, if you take a list of parameters that have been fine-tuned based on input and sophisticated algorithms, that sounds exactly like the way you might create a database that's protected as a database right. If, on the other hand, you look at the individual weights on nodes in the neural network, you may look at it and say, does that even cross the information threshold? Or is this a database of information? Can you query it to get, for any meaningful reason, a weight of a particular axon? And does that mean anything? And I think perhaps not. So I think we're going to need the courts to give us an answer to that. My suspicion is that my personal view is that an LLM, the weights, the parameters are not a database, and I also don't think that they are neatly protected by any of these. I suspect that the best characterization of them would be as confidential information, really. They're certainly not trademarks. You're not going to get a patent for any of this stuff. They're not a database. They'd be meaningless to extract the weight of a particular node. Copyright isn't going to protect the parameters. So I don't think we currently have IP rights that are on all fours with it. I don't think that's a bad thing.
It's a general question. I didn't know databases were.
No, because if someone is creating their own LLM, that should be an IP.
No, but that's the question.
And I think the answer is that it possibly isn't.
Surely, though, with prompt engineering being a job, where your job is to create those prompts.
So the prompt would be covered by copyright, undoubtedly. But the LLM, a list of weights.
So if we are using an open source LLM and modifying it according to the data we have, that should not be protected because that's open source. But if we are creating our own models, then that's.
Under what framework? That's
Yeah.
the question. What framework?
What type of IP feels like a good fit for that?
Again, that's.
So, yeah, but a patent protects an innovation. Theoretically, you could have, it may be that you might, if you've done it correctly and at the right time, get a patent for, attention in the way that you're operating an LLM. But that would be the innovation, not the actual, not the data.
Your investment is to compute, but given that space is supposed to be 10 million on compute, you can't protect it from what you said so far.
Yeah, I understand. But that's why I asked. That's why I realized. Are you talking about the code or are you talking about the data? Because
No,
that's
it's separate. No, the data is data. You spend some compute to generate an LLM. You can't protect it.
But surely we have a system that takes inputs from lots of different things. So active creation that we can copyright is how we interact with those things, which surely is a very similar process in how we build models, right? How we choose to adjust and how we do that. That's an active creation, even if the outputs aren't our own creations.
Yes, yeah, I agree. And you might make it, you could draw an analogy between, I think, if I've grasped what you're talking about, that and the format for a TV show, or a way of doing things, a heuristic. And heuristics are not generally, well, I mean, theoretically they could be patentable, but a heuristic or a technique, a way of doing things isn't going to be protected by copyright. The manuals that describe how to do it might be, but the secret source in that sense generally would be confidential information rather than an actual IP right.
Is it like the Google algorithm?
So again, a tricky one. Yeah, kind of is. An algorithm is not generally protectable as through any of these. The way you implement the algorithm, so the specific code you write to implement the algorithm, would be protected by copyright, but that doesn't mean that it would stop someone else from achieving the same thing with their own code, as long as they didn't copy what you were doing, if that makes sense.
Hi, Stefano. Sorry, this is really great and interesting talk so far, but I'm going to maybe shift the direction a little bit. I'm really interested in health data, and obviously health data has more specific provisions than just general personal data. My question to you is, have you had experience working with health tech companies? And kind of if so, have you got any advice for, say, maybe a new health tech startup as to how to go about making sure that they're acting in compliance with rules and regulations?
Yeah, tricky, as it sounds like you've experienced. So health data is protected on top of the legal bases I mentioned. You also need to satisfy additional criteria because it's characterized as special category data. And depending on what you're doing, it may well be that the data you're using is health data, but it's been made public. And this is one of those interesting situations where actually data being public makes it easier to use. Well, it typically would make it easier to use, but has a meaningful impact. So one of your special category conditions, I don't know if you follow that, could be that someone's made their data about their health manifestly public. So that surprisingly, that can actually prove a useful avenue for some people, depending on what you're doing in health tech. But perhaps we catch up after and we could talk about the specifics.
Hello. Thank you so much for the talk. It was very interesting and useful to put things into perspective. I have a question connected to a personal anecdote, and it has to do with automatic decision making and the right to at least know how the decision is made. So I tried to get a broadband to my house, but they ran a check with Experian, and I got refused. And interestingly, I have worked for Experian and created credit risk models, so I got really angry because that's not how you're using the models. And anyway, they were probably not using a model, but just some checks. Yeah. But I thought that I should have the right to know why, and they wouldn't tell me because Experian told them something and that's all they knew. And I really want to know, is this correct? Because it felt like I should be protected in this case.
So I agree with you. I think you should get details. I think you should be told. The reason why there can sometimes be an out for this kind of thing is that there are a myriad exemptions and exceptions under things like the Data Protection Act, which cover things like if you're using information in a particular way to, for example, detect or prevent fraud, which will be one of the things that I suspect Experian might rely on in this instance, that gives you grounds to not provide certain information.
But in this case, it's like a service, like a broadband connection. I cannot fraud them, basically.
Yeah, I mean, let's chat up afterwards. Like, I'd love to be able to help. Let's talk about it. It's a tricky one, but I mean, yeah. For context, you could be, whether a credit reference agency or someone else, if you were collecting information that is used to generate a result where that result is where the objective you're pursuing is to prevent crime, fraud, that kind of thing. If they can justify that, then they may well be able to withhold details from you, because on the basis that if they tell everyone how the secret source works, then the real fraudsters will get past it, if that makes sense. But no, great to talk about it.
Thank you so much, Stefano. Can we give
That's right.